Don't forget, you can reach the latest episode of Potomac Watch anytime. Just ask your smart speaker, play the Opinion Potomac Watch podcast.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. The last incentive here that I want to bring up is the incentive to launch a generic pharmaceutical product, because that costs a lot of money to do as well. And Kim, it seems to me that part of the calculation, if you are considering a generic, is what the gap is between what you think you can price at and what the brand name price is, because that's going to affect how many people you think you can get to switch from the brand name to the generic. And it seems like it gets much more complicated if you start worrying that, you're going to get down the pipeline in launching this generic, and then the brand name is going to get under government price controls. I mean, you may have wasted your capital. You may decide that you're not going to launch that generic anyway. I mean, it seems like it puts a chill on the generic business, which is one of the prime ways of making prescriptions cheaper and saving patients a heck of a lot of money.
This just goes to how backward this entire new program is. I mean, if you look out there, you heard the president, again, I can't get over that comment he made, which is just so deceptive. If you look out there at the overall healthcare world, and I think Alicia touched on this, the rate of prescription drug costs has actually grown far more slowly than that of hospital and physician services overall over the past decade. And right now, the total out-of-pocket prescription drug spending, real dollars, is less now than it was in 2003, and only equals about 1% of U.S. spending on healthcare in 2021. Why is that? In part because we have a pretty good generics law, and it encourages people to get out there and compete in that regard. We try to, under patent law, make sure that companies that do the original innovation get the fruits of their investment dollars, but we balance that against letting other people come in as competitors at a certain time. The joke of this particular program and some of these initial drugs is that a couple of them were very soon up for generic competition, meaning that if they had just remained off the list, they were soon going to get a bunch of competitors that would lower the prices of this anyway. All of those that are on the list are certainly in line for some kind of generic competition down the road. Will that happen now? Probably not, because of what you just said. Who wants to key themselves up for now government price controls for having gone into that market? I think the other thing that just shows how backward this is it was unnecessary. If you're really concerned about the amount of money that seniors are paying for their drugs, even though I would argue it's vastly overstated by the government, you can cap their out-of-pocket costs, have the government cover a bit more of that. You can do a lot of this without fundamentally taking the steps that this program does of absolutely kneecapping innovation. And by the way, at a time where we are seeing a renaissance in certain areas of drugs innovation and cancer and other areas of research, we should be applauding that, doing all we can to encourage that. This program is the opposite.
But the question now will go to the courts about whether this can actually take effect and whether it is constitutional. There are some lawsuits percolating. One of them I will point to is filed in June in Ohio federal court by parties including the U.S. Chamber of Commerce. And they make a few arguments. One of them is that this is a non-delegation problem, Congress handing off too much power to these administrative agencies. The Inflation Reduction Act centralizes vast, unreviewable power in the hands of an administrative agency without the ordinary protections of due process to decide the fate of the $600 billion pharmaceutical industry and every American who relies on it. Another argument that they make is pointing to the excessive fines prohibition in the United States Constitution. And then the lawsuit says that the penalty for not negotiating the government price is grossly disproportionate. It can amount to 1,900% of the total daily revenues for all sales of the relevant drug. If the plaintiffs say they're not aware of any other statute that imposes similarly severe sanctions on comparable behavior. And Alicia, in addition to watching the pharmaceutical industry, you are a watcher of the federal courts and the U.S. Supreme Court. So what do you make of the arguments that the U.S. Chamber of Commerce and these drug companies are making against the Inflation Reduction Act price caps? And do you think they'll get some traction in the federal courts?
So there are 8 lawsuits actually in the federal courts, 6 by drug makers, 1 by the Chamber of Commerce, and another, from pharma lobby. And they make, as you point out, the excessive fines under the 8th Amendment prohibition. They also make what I think is also a very strong case on fines, and the price controls constitute property takings under the 5th Amendment without just compensation. Merck argued this in a lawsuit, I think also filed in June, pointing to the Supreme Court's Horn precedent, which held that the Department of Agriculture couldn't require raisin farmers to turn over a portion of their crop to the government, because that would be a per se taking. And the IRA, they basically argued, was similarly compels manufacturers to surrender their drugs to the government without just compensation. Now, the Supreme Court has really been bolstering property rights in recent years. So I think that they make a strong argument there. And again, on the 8th Amendment, but also that some of the drug makers make kind of a novel argument under the First Amendment that the law basically compels commercial speech, that they have to essentially echo what the government's Orwellian language, that they are agreeing to a maximum fair price and that this is an agreement and that this is essentially, they have a choice in the matter. It's an interesting argument. I think the stronger arguments are the 5th and 8th Amendment, and perhaps there are also AstraZeneca raised in the lawsuit last week, some also arguments under the Administrative Procedure Act in terms of the regulations that the CMS promulgated in terms of actually specifying how these negotiations would play out. But I could see that this is definitely going to the Supreme Court, because you're probably going to get a circuit split with all these cases percolating in lower courts. And if I had to guess, what would ultimately end up happening is that the Supreme Court will strike down the penalty or the excise tax. And the question then will turn on severability. And recall what happened with the Obamacare and the Medicaid mandate, and whether the court actually, in that case, kind of rewrote the law to uphold the Medicaid expansion, but it didn't strike down the entire law. And there was kind of the conservatives dissented on that in that decision. And I think that's going to come up again here, whether does the entire negotiations, do they get struck down entirely if the excise tax is ruled unconstitutional? I think that's interesting. And I think that that's really what people should be watching. I think there's a very strong argument that they should be, because so much of the negotiations hinge on this excise tax. And it really gives an incentive by upholding the entire program, gives an incentive basically for Congress members to kind of legislate a little recklessly. Oh, well, this may be unconstitutional, but nonetheless, even if it gets struck down, the rest of it could still stand. So I would expect the Supreme Court to probably consider the case in the next couple of years. Again, the negotiations are expected to start this year. So I would actually also expect a federal injunction in one of the district courts soon, before they are supposed to start next month. And then ultimately this going up to the high court in the next 2 years.
Thank you, Alicia and Kim. Thank you all for listening. You can email us at pwpodcast@wsj.com. If you like the show, please hit that subscribe button, and we'll be back tomorrow with another edition of Potomac Watch.